Good afternoon. I'm John Lindsey, Major Lindsey in Africa. As a recruiter who spent the last 25 years working with successful lawyers, I am always keenly interested in the career arcs of superstar attorneys. Our two speakers, Mary Jo White and Stephen Cutler, have a number of things in common in addition to being superstars. The first and foremost is the fact that both of them have had distinguished careers as public servants. Steve as Director of Enforcement for the SEC, Mary Jo in 5 different positions, including U.S. Attorney for the Southern District of New York, and most recently as Chair of the SEC. The second thing that they have in common is that they both left public service to return to the private sector. In Mary Jo's case, she's been hired by Debevoise and Plimpton a total of 6 times, and I can tell you as an expert in this field that that is both a world record and an Olympic record. So the question this raises for me is, and perhaps our friends at Bloomberg can help shed some light on this, why is it that every time a lawyer leaves public service, leaves a government job where they've worked incredibly long hours, stressful hours, enforcing the government's rules and regulations, where they're being paid less than a 4th-year associate. Every time that happens, there's an article that uses the term revolving door in a very ominous tone, that somehow this is a bad thing. I think it's a wonderful image. It's you see that door revolving around, but I also think it's monumentally unfair. And I think instead of criticizing people going on their way out, we should be applauding them on their way in, because very often they're making incredibly huge sacrifices, personal sacrifices, family sacrifices, financial sacrifices, certainly, that they're willing to make in order to make a contribution to the common good. I don't think anyone really believes that an assistant U.S. attorney or an enforcement lawyer for the SEC is going to go easy on someone because they think it's going to get them their next job. If anything, it's the opposite. You prove that you are attractive to future employees. You're good at what you do by beating the heck out of somebody. You prosecute them aggressively. You don't let them go. And in any event, you wouldn't end up going to work for the very entity that you prosecuted. So to me, that is just a very bizarre argument. So if all this sounds a little personal on my part, it's because I've looked up to Mary Jo White for more than 4 decades, and figuratively, not literally. She was my very first boss in the legal profession. I was the brand new editor of the Columbia Law Review, and she was trying to get all of us puppies to do our site checking and blue booking. I had so much admiration and respect for Mary Jo that for a while I even followed her around, first to clerkships at the courthouse in Foley Square, then to Debevoise, and then to the U.S. Attorney's Office, where we were both assistants. At that point, our career paths diverged, you might have been able to tell. Mary Jo and Steve have been fortunate enough to see the regulatory and enforcement machinery from both sides, and obviously from the very highest levels. As the vice chair of JPMorgan Chase, Steve also has the additional perspective that you can only get when you're occasionally the target of the enforcers, or when your employer is. We are equally fortunate to have them here today. They're going to be sharing their insights on what I think is a pretty uncertain regulatory environment that companies and financial institutions are going to face in these perilous times. I'm going to turn over the proceedings to our distinguished moderator and interrogator, David Gura, an award-winning reporter and Bloomberg anchor who is going to be grilling Steve and Mary Jo on the future of Dodd-Frank, perhaps the future of Glass-Steagall, and who knows, perhaps the future of democracy as we know it. So, David.
Well, let's start with how the regulatory landscape looks to each of you right now. We heard from Cheryl that great overview of how things have changed in Washington. Obviously, an independent agency like the SEC is in a bit different position, but that overarching sense of regulatory change seems to be there. What's your sense of the landscape right now in Washington? I'll start with you.
I mean, clearly there's a change in philosophy. I mean, there's no question about that. I think what dominates now is just uncertainty as to how significant that's going to be and what it's going to be. Certainly it's the Choice Act, which people are familiar with, probably will pass the House and may go no further than that. So right now I think it's a philosophy change, but very unclear just how much real change will be affected by that, at least in terms of legislation and regulation. What the regulators themselves will do under that new philosophy, though, I think is not insignificant, even if there aren't legislative and regulatory changes. It'll be interesting to see when the Secretary of Treasury comes out with his reports to the White House, which I guess begin like next week or the following week with the banking industry and then the markets, which is really to study what's out there that ought to be changed in order to become more deregulatory, I think. And that may give us more of a roadmap, or it may not.
Steve, your vantages from a big bank, how does it look to you from down?
Well, a lot of people have said that personnel is policy, and we're still missing a lot of personnel. Sort of 4 months in, I think I hesitate to use numbers that I know I'm wrong about, but on the order of magnitude, 500 some odd positions need Senate confirmation, and 400 some odd still haven't received it. Indeed, probably haven't even received nominations. So I think we're a long way away from accomplishing a significant change in the regulatory agenda, even if one were to have that agenda. And it's not clear to me that it's as broad sweeping as a lot of people thought it would be, and as a lot of people maybe hoped it would be just several months ago.
Let's talk about personnel in the context of the SEC, in which both of you have served. And Steve, I'll ask you sort of what we know about Jay Clayton and what you heard in his confirmation hearings, what you know from his background, how that might give you a sense of what kind of leader he's going to be of the Commission at this point. Yeah,
well, I'd start by saying I actually think he's a great choice. Number one, I think he's really smart. Number two, he's practical. And number three, he is a very likable, approachable person, and I wouldn't discount the importance of that. I should say he's no Mary Jo White.
He's a lot taller.
But, and he obviously has a deep background in capital markets and, transactions, and I think that will serve him incredibly well. Look, he's going to have a different area of focus or emphasis than Mary Jo did, and I'll let Mary Jo speak about that. But, I am very optimistic about Jay's prospective tenure as chair.
Ask you a bit about that. I was going to share an anecdote here. I used to live in D.C., and our daughter went to the SEC daycare, and I was telling you I have fond memories of you being in the lobby, greeting staffers at the SEC, I think every quarter, giving out cookies and coffee and all of that.
It's all part of the job.
It's all part. So in terms of likability, I want to make sure we have that
full service,
that's squared away. Maybe I'll ask you for your reaction to Jay Clayton's appointment, but on top of that, sort of what power does an individual have to shape the direction of the Commission? Yeah,
let me, first, by the way, I was very pleased with how the morale of the SEC, the staff went up in the years that we were down there. I mean, I don't know if it was the donuts or the cookies, but it might have been, you never know. Look, first, I agree with everything Steve said about Jay Clayton. I think he's a terrific choice. He's smart, as Steve says. He's highly principled. He's knowledgeable. He's clearly focused on, I think it was what Steve was alluding to, and he said so in his confirmation hearing, and this would make sense given his background also, on IPOs as one issue, which is, how come there are fewer IPOs in the last 10 years? How come companies are slower, going public, and looking to see whether there's some regulatory barriers that may be causing that. So I expect a lot of very strong activity in the corp fin space, including that. In answer to your question of how much, look, I think the chairman of the SEC, even though only one vote on a commission of 5, so in order to get
when
anything,
it's full,
and only one vote of 3 or 2 or whatever when it isn't full. So you have to, you can't act in many respects unless you have at least 2 other votes with you when you have a full commission. But the staff reports to you. You dictate the agenda as the chair, so that the commission can't vote on anything you as chair don't give them to vote on. So I think, unlike, frankly, in some of the other agencies, I think the chairman has a lot to do with, what the SEC does in a particular, period of time.
Steve, let me ask you about the balance of power among regulators at this point. Again, you're at a bank looking at the regulatory landscape. Do you see the DOJ taking on a bigger role than it has in the past when it comes to banking regulation. Do you sense that there's going to be a sort of seismic shift in that way, that an institution is going to have more power under this administration than it did previously?
I think when it comes to bank regulation, the answer has to be no if you're talking about DOJ. And in fact, you could look at some of what DOJ did over the last 4 or 5 years, and you could say that it was acting as quasi-regulator in the context of the criminal and enforcement actions that it was bringing, both under FIREA and otherwise. I got to believe that that will be a little bit more constrained, and so that when it comes to regulation, look, if you're a bank, you're thinking first and foremost about the Fed, and if you're a national bank, the OCC. And then you're going to think with respect to your various businesses about things like the SEC, the CFTC, the CFPB, depending on what it is you're doing. Look, one of the things I think we missed an opportunity on, going back to Dodd-Frank, is regulatory rationalization. We used to draw up a chart that would have the regulators at the top and our principal businesses at the bottom, and just start drawing lines. Which regulator regulates which businesses, and we used to call it, for obvious reasons, the spaghetti chart. And that's not something that we solve. That's not something that anyone's talking about solving anytime soon. But I do think it's something that, in the long run, and that's the way I try to think, it is an issue that we should address as a country, is just rationalizing this.
A number of Fed governors have been speaking out on this issue. Jay Powell, speaking a few weeks back, said, quote, "The new rule book is excessively complex. We need to look for ways to simplify the rules so that they support our goals, but also improve the efficiency of regulation." Mary Jo, how do you begin to affect that kind of change?
Well, I think to some degree you're hampered, certainly in the Dodd-Frank mandate era, doing that, because the statutes are often very prescriptive, which limits your ability to make it simpler, even when you can. But I think, the regulators should have learned, I think, for example, from the experience of the Volcker rule, which is enormously complex. May have been what Jay Powell was talking about in particular, that, how do you obey a rule that's that complicated? How do you, check for compliance? How do you even bring an enforcement case? So it's your goal to make your rules as workable as possible. That tends to translate often into simpler rules. But often you can't, either because you have statutory prescriptions or because in order to draw some of those fine lines, even taking Volcker itself, you're exempting out market making, you're exempting out underwriting. Well, when do you have which one, right? And so that's a complicated process. The other way, though, that you can simplify more easily, I think, is, again, going back to what Steve was talking about, is just overlapping regulators. Even on Volcker, when you have 5 regulators that, somebody has the primary ticket, but everybody kind of has the ticket to enforce. That's something that I'm not sure, Steve, politically, that gets unraveled, the rationalization you're talking about. But, that would be a huge step forward, I think, if it could be, not just in the enforcement space, but in the regulatory space as well. I have heard, I have no idea whether this was just an observation that, at one moment and it will not happen, but that there's thoughts about using FSOC, the Financial Stability Oversight Council, where you do have all the major federal financial regulators in the room. The state's still out there, obviously, which is another topic in and of itself, to really try to bring the regulators together to simplify, both simplify the regulations they each have on the books, but also to deconflict them. I'll believe it when I see it, but yeah. But
and by the way, you're absolutely right. It ain't going to happen, when you think about just, rationalizing the number of regulators we have. And the next step is, can we take some of these rules where, so Volcker is one where there are 5 different regulators, your old agency had to weigh in on. When we look at something like mortgage servicing, putting the states aside, because every state may have its own set of rules, you've got 7 different federal agencies that are involved in dictating the terms of mortgage servicing. And when we look at the mortgage, there's like a 14,000-page essentially rule book for the origination and servicing of mortgages. That's probably not ideal, is my guess.
Right. You know what, the 2 agencies that I would watch,
Yeah.
I don't know what's going to happen there, but just in terms of change, one would be the Fed, because there's been lots of talk in the prior administration from the other party now in power, the Republicans, that the Fed has gotten too powerful and they're in too many places. You've also got change in personnel there to some degree. Jay Powell will be more active now that Dan Tarullo has left, has somewhat different attitudes. The other agency to look at is the CFPB, I think, and what happens there. The most logical way to deconflict two agencies would obviously be the SEC and the CFTC, but politically it won't happen. I mean, you have two different congressional oversight committees, agriculture and, House Financial Services, and neither will give up their turf.
Steve, what did you make of Dan Tarullo's valedictory speech he gave at Princeton? And he said it's crucial that the strong capital regime be maintained, especially as it applies to the most systemically important banks. It was a strong speech, one I think that had wide reverberation. Do you think it's going to have an effect going forward?
Well, I think it's actually very hard to argue with that principle.
Yeah.
The system is better today than it was in 2007. There's just no question about that. And part of that is that there is more capital, there is more safety in the system, there is more liquidity in the system. And, the question we all have to ask is, did we calibrate it appropriately? I think there are a lot of people who would argue, and I'm no expert on this, that we're excessively capitalized, and there is an impact on how much lending you can do, what kind of lubricant you can serve to the economy to the extent that you've got money and capital squirreled away. And that's what we have to take a close look at. But the general principle, I think, is unassailable. We want a system that's safer than it was, and I think capital regulation has done a lot of that. Do we need the gold plating on top of international standards? Have we become less competitive? And you hear talk about more capital, and at some point, it really does become counterproductive.
So as the writing of regulation, or the rewriting of regulation comes to the fore in Washington, perhaps, what would you say we've learned from these last 7 years since Dodd-Frank was signed into law about the process, how it's unfolded? You mentioned the amount of time it took away from what you might have liked to have on your agenda when you were at the SEC. What have we learned over the last 7 years?
Well, I think, first I agree with Steve that I think the core financial system is much stronger because of many of those rules. But if you look at all the Dodd-Frank mandates, and frankly even the Jobs Act mandates, some of those rules make a lot more sense than others, and yet they're all mandated to do, at the agency. So I would hope we had learned, but I'm not sure we have, looking at the Choice Act, that you leave to the expertise of the agencies, the independent agencies, what rules make most sense. And make them more workable, make them more cost efficient. I think lots of folks agree with that, but what you don't see is that being translated into Hill speak in terms of what's proposed by way of legislation. I think the overlap issue is there. I think we've learned that you really can't have 5 different regulators enforcing the same rule. It doesn't work. So I think we've learned that as well. It's an enormously time-consuming process to do any of these rules. Some would say that's maybe a good thing because you might do fewer. And clearly you want to do cost-benefit, economic impact analysis. But the requirements of the Administrative Procedure Act and make them more complicated and take longer than they should. So, what I would say we've learned is we shouldn't have so many rules mandated by Congress. Leave it to the expertise of the agencies.
Let me follow up on that. Just ask you about the fiduciary, so-called fiduciary rule. We had the new Labor Secretary yesterday saying that he hopes in this administration the SEC will take a greater role in that. You don't have to defend not taking a role in that when you were at the SEC. But what does that say to you about communication among agencies and who does what?
Well, look, I think it says a lot of things about what we've already talked about as well. First of all, one of the most controversial rules during the last few years has been the Labor Department's fiduciary duty rule, and yet, the new administration has decided it will become effective. Now, obviously, lots of, businesses changed in conformance with that, which basically imposes that uniform fiduciary duty on, brokers as well as investment advisors in the ERISA space. And so, that's the authority of the Department of Labor. The SEC, doesn't have that specific authority, but does have authority over broker-dealers and advisors. The SEC was given authority under Dodd-Frank if it chose to do so, to do a uniform fiduciary duty rule. I decided, as my one vote, as my other commissioners reminded me, that I thought we should do it, actually, but made very clear that, and the SEC's been studying this for like decades as to whether to do it or not, that it would take a long time and it was very complicated, and you wanted to do it well so that you were not driving out of the marketplace reliable, reasonably priced advice to retail investors. But once we became a 3-person commission, it was impossible for me to advance that because both of my other commissioners were opposed to it for different reasons. Now it's come back, and one of those commissioners, incidentally, I have seen quoted saying, well, now that Trump is president, perhaps we can do that now. I'm not sure of the logic of that, mind you. But, the SEC clearly helped in the sense of providing technical assistance to the Department of Labor. I think it's an important rule to do, and to do it well. Essentially, the posture of it now is the SEC has not moved forward, although there is an outline of a proposal that's sitting there for Jay Clayton. I'm sure he's studying it at the SEC to do its own rule. Labor has put out for comment about how should we change this rule that is going to become effective, and invited the SEC to be an active participant. I think it's a good idea for the SEC to be an active participant.
What's awkward, I think,
Yeah.
in the current state, or the current state to be post June 9th or something, and then January of next year, is one set of rules for essentially IRAs, and then another set of rules for other kinds of accounts that customers have with the same firms. We talked about regulatory overlap and duplication, and this is one area where I really do think it made sense for a single regulator to say, hey, here's what makes sense.
Yeah. And that could have only been the SEC.
Exactly, because
right.
the DOL did not have jurisdiction over outside of ERISA.
Now, a lot of firms, I think, you know better than I, have actually applied that rule, across spaces, right? I mean, to non-ERISA accounts as well.
Some firms have, but again, not because they necessarily said, hey, this is the way the world should be. They just said this is the way the world has to be, given that this is what the Department of Labor has said about ERISA accounts. And I just don't think that's an ideal world to be in. So,
I agree.
A few moments ago, you brought up the IPO pipeline, which has been slow. Some would say glacial for a while here. Let's dig into that a little bit. I know it's complex, but what do you think some of the reasons are it has been so slow, and what power does the government have to perhaps catalyze that more than it has?
Jay Clayton figures that out, and actually it makes some changes that make some difference. But I will say that's an issue I was also quite interested in, not coming from the same body of expertise in the deal space as Jay does, but very interested in it. And lots of other things on our plate, so I didn't do as much work in the areas I might have liked to. But my tentative conclusion was that because the private markets have become so much stronger and deeper and broader with liquidity, that may well be the primary reason we see the change in IPOs. And when Jay's looking at this to see whether there are regulatory barriers that ought to be removed and yet still obviously protect investors, I think you've got to look not just at what are the barriers to going public, but also, because the Jobs Act did a fair amount, for certainly emerging growth companies there to make it somewhat easier. And I don't know if it's all of the IPOs since the Jobs Act have been, emerging growth companies, but most of them have anyway. But you've also got to look at what does it mean then to be a public reporting company? And, is there anything there that's providing a disincentive that doesn't need to be there? Those are two separate questions. So, it's not an easy subject.
Want to take a bite at that?
Yeah, I mean, first of all, I agree with Mary Jo. You have to actually think about both sides of this equation. And I think the private markets have become larger, more liquid, provide more opportunities for companies than there might have been in the old days. I think in the old days, I think the way a lot of private companies would think about life is, the grand bargain is, if I want capital, I have to do the things that come with that, come with my status as a public company, and some of those aren't so appealing, but I got to do them in order to raise capital. I think as it's become easier to raise capital, that grand bargain is no longer a bargain. And, there are companies that are saying to themselves, why would I want that? Why do I want the burdens of becoming a public company? Because there are burdens in becoming a public company. The thing we ought to look at is not just are there fewer public companies, but are there fewer in the U.S. versus elsewhere? And are there things happening in the regulatory world, and probably just as importantly, maybe more importantly, the private litigation world? And I would say, unfortunately, that's one commodity that we're doing a pretty good job of beginning to export. But I think at least until now, companies have thought about their private litigation exposure in Europe and Asia differently than they would in the U.S. Again, that may be changing, but that may be part of the equation as well.
We talked before talking here about the role of regulation in the boardroom. How heavy is that? How much could that be lightened, do you think?
I mean, I think this was a comment Jay Powell made recently also, that you have so many, some would argue, check-the-box compliance responsibilities, many of which are obviously, at least in some sense, the board's responsibility as well, that the board really isn't able to, focus on its primary fiduciary duty to the shareholders and the company in terms of the company's business, its growth, et cetera. But Steve, we should defer to Steve on that. He deals with those boards himself.
Yeah.
Well, when I think about what our board agenda looked like when I first got to JPMorgan in 2007, and then what it looked like when I stepped down from the general counsel role about a year and a half ago, the amount of time and energy being spent on, call it regulation writ large, so compliance, litigation, risk, legal, audit, those functions, I think had gone up exponentially. It probably needed to go up. The question is, have we gone too far? And I think the same thing about management as well. It's one thing for the general counsel to spend 100% of his time on regulatory matters, but when you have very senior managers of very big businesses spending a huge percentage of their time thinking about nothing but the next OCC exam or the next audit or the next Fed exam, that's probably not healthy either. And again, the question is, do we have this balance right?
I'll ask a couple more questions, then we'll open the floor for questions. Let me ask you about enforcement. Both of you have experience with enforcement. You, back in 2013, delivered a speech in which you called for more muscular enforcement at the SEC.
She didn't mean it.
She didn't mean it. Are you satisfied with where we've gotten? And is that something that you think stands to change? Is that something? Yeah.
I'm sorry.
Yeah.
I'm not sure. No. Look, I think I came into the. I mean, in one of my prior lives, I was the U.S. attorney with the criminal powers. You come into the SEC, and it is obviously very much a law enforcement agency, civil law enforcement agency, but it has lots and lots of other responsibilities. So it's really kind of a different, arena to some degree. And I came into the SEC after my predecessors, I think, in some ways had strengthened enforcement in some areas and certainly the structure of enforcement. I mean, look, it is my background. I mean, I did adopt in consultation with my fellow commissioners and the division director of enforcement, the admissions policy that was so, popular with everyone, which I thought was necessary, which in some cases that settling defendants needed to admit their wrongdoing in order to give greater credibility to settlements and create a greater deterrent effect. I think we did about 80 of those. And then it's sort of no good deed goes unpunished. Then I was beaten by the politicians for not doing more of those. But I still think it was a good change. I mean, I think, there were record numbers of enforcement cases. I also feel about enforcement, you're called lots of names when you're in the private sector and in the public sector. But the one name that I was called as U.S. Attorney and still was called, by some at least, as SEC Chair in the enforcement space was tough but fair, and that's really kind of what I think of as the right place to be. What I was distressed by was seeing that the enforcement function also tends to get politicized unless you really stop it from getting politicized. And so, whereas I sort of started thinking, wouldn't it be great if the SEC were given also the criminal powers, which I would like to have had for egregious cases. And then I thought, I really don't want that in the SEC with a politicized commission to deal with it. I mean, you need to approach the enforcement with toughness. I think we did. I was very pleased with the results from a lot of perspectives, but also humility, I think.
Steve, I'll just ask you, do you think it stands to change, the Enforcement Division, its objectives under Jake Lynn? Do you think that'll change?
Not a lot.
Yeah.
Mary Jo's too modest to ask you to read something that she said or wrote during her tenure at the SEC, but I think we'll look back on the speech that you gave, I think in your last couple of days in office at the SEC, about the politicization of the agency and how dangerous that is. And indeed, you point out in particular in the enforcement arena, I'm a Hamilton fan, and I've become a lot more familiar with the George Washington farewell speech. That speech to the country is what your speech will be to those who follow the SEC, I think, one day. And I actually think that Washington would do well to read that speech and to hearken back to the days when the SEC was one of the gems of Washington because it was an agency of expertise, not an agency of politicians. So I hope we can get back there.
I will look forward to the musical.
I'm younger than George. Yes, and I'm younger than George Washington. I want this to make it, but thank you, Steve.
So what was that? What was I supposed to? What was the question you did
Yeah,
ask
right,
me?
right. What was
I
that?
answered whatever I wanted to answer.
Well said.
Something about enforcement.
Yeah.
Something-
Do you think it's going to change?
Is it going to change?
Yeah, might it change at the edges?
Yeah, I agree with that.
Yeah, but there's just some bread and butter stuff. And I think Jay's going to keep doing it. I think the agency's going to keep doing it. And, there are 1,000 staffers that's what
They do.
That's what they do.
Yeah. It's also, if you look in my era down there as well, where you really did have, I think, perhaps more 3-2 votes on policy matters, perhaps in the history of the agency, given all the particularly given all the Dodd-Frank rulemaking, because we had almost all of the enforcement cases were unanimous. So enforcement tends to be, except maybe around the edges and some of the, and some different theories of liability, perhaps, pretty much bipartisan, I think. So I don't expect dramatic changes there.
Okay, so I ask a last question. Let's raise your hand if you have one, and we'll come around with some mics and take your questions as well. Let's take a bite of John's question, or the issue that he raised, how we encourage people to go into public service. Amid all of the uncertainty, amid all the political pressures you've just been talking about, what do you say to somebody, you spoke to Columbia Law School last week, what do you say to somebody who's considering it but is worried about perhaps the financial stresses of it, the political stresses of it? What do you say to him or her about the path through public service?
Well, that piece is very much part of the territory, the criticism and the politicians and the editorial writers and so forth. And it's not like anybody loves that when you're the victim of it or at the short end of that stick. You have to be able to sort of take that and expect that. But look, I love practicing law. I've 6 times I'm back doing it. I love doing that. But I also get a tremendous satisfaction out of public service, certainly at the right places in public service. In my case, the U.S. Attorney's Office, and the SEC, an independent agency where the staff is really dedicated to its mission. Look, you are, as I see my responsibility in both of those places of public service, every day people will disagree with you. You may be wrong sometimes, but every day you basically go to work and say, I'm going to try to do the right thing in the right way. That's hard work to come by, and it's really, really satisfying work. Although I will admit to visitors coming through Washington from time to time, and I would say, you realize I'm actually paying to be abused in this manner, right? Not only am I making no money, right? I'm paying for my commute from New York every week. I'm paying for a second residence. So, but it's the public service. Somebody asked me, well, why did you agree to do this, right? Maybe it's Steve, actually. And I said, well, when the president asks you to do a public service, you do a public service. And so it's extraordinarily satisfying. I'm a great proponent of spending, for lawyers, and I think I did say this at Columbia last week, some of your career in both sectors.
So what do you say to those who are critical of what they call the revolving door, of going in and out? How do you counter that argument, or how do you...
Why bother? It's just, it's in its extreme form, which is now its, non-extreme form. It makes absolutely no sense at all. I think, it's, first of all, I started in the private sector. I've never parlayed I've been at the same firm 6 times. I've never parlayed anything into anything, basically. But the idea that you would not want people who are expert and knowledgeable in these public service agencies is just crazy. And I think, and I'm absolutely convinced that the fact that I was in the private sector and exposed to what I was exposed to in the private sector made me a much stronger U.S. attorney and maybe a much stronger chairman of the SEC. I was more knowledgeable. I knew where the pressure points were. I knew where the leverage was. You do need to pay attention, obviously, to any conflicts that are, created by that. Pay very close attention and deal with that. But people do deal with them. They take them, very seriously. So I think the public is benefited, by people who have been in both sectors.
Let's take some questions, if you have any. Lawyers,
Gee.
not eager to speak.
Yankees,
Right here, go here.
Have you seen a shift, or do you think you will see a shift in terms of individual accountability that was sort of
I'll just reiterate that because he didn't have a mic. A shift in individual accountability in light of the Sally Yates memo.
Yeah, I mean, I think first of all, the SEC, I think, in particular, has always focused on individuals. I think 75% of the cases involved individuals as well as firms. Lots of the cases during the financial crisis, which is where you sort of got that criticism of why aren't individuals being held accountable. The SEC, I think, had, 180 cases and about 90 senior executives charged. And prosecutors, going to the DOJ side, I mean, you're most interested in who did it, right? The person who did it, and where is that personal responsibility? My concern is that it's too easy for a prosecutor or an enforcement lawyer to charge and get a big settlement with firms. And so one of the little tweaks that I made at the SEC, and Andrew Seresny, our director of enforcement, made, was to say to the staff, start with, and it's very subtle really, but I think it may apply to the Yates memo, start with the individual who you think did something wrong and didn't do their job, and then work outwards to see whether you think the entity ought to be held responsible. So DOJ had, as you know, a fair number of mega billion-dollar resolutions with not a single individual charged in them. I think that undermines the credibility of enforcement, frankly. And so I think the Yates memo didn't really plow new territory, but I think refocused the staff of DOJ on, look, start with the individual and work outwards. I don't know how much impact it's going to have. I mean, I think it's enormously important that that is the primary focus, though.
Steve, you want to weigh in on that?
The only thing I'd want to echo is what Mary Jo said about the interactions between the government and institutions, and I think this is particularly true in the financial services sector. Your prosecutor is also your judge. And I think the prosecutors know that, the enforcers know that there's no opportunity to actually get before somebody in a black robe. And that means that I think the prosecutor or enforcer has to have a greater sense of responsibility, if you will, for making sure that they've got it right. And I hope that's what that's what we see maybe a little bit more sensitivity to over the next several years.
Over here.
Piggyback on that. Thank you. Can you comment on enforcement of third parties, i.e. lawyers in some instances, and where you see that headed?
I mean, I think I'll speak from the SEC perspective. I mean, the SEC, and me personally included, really focuses on gatekeepers. Lawyers are among those, obviously. Accountants are among those. I mean, I think directors are among those, because you really, count on those gatekeepers to police, the markets and the firms that they work for the, benefit of investors in the markets. And so that's sort of, and chief compliance officers, I didn't mean to leave the main ones out, right? Same thing, same attitude. And so we got into a situation with commissioners issuing competing statements when I was chairman, when we charged a chief compliance officer in a case about, what are we doing here? We're going to drive good people away for, basically trying to put up their hand and maybe not do their own job, but somebody else's job. Obviously, we have to be very careful about that. I mean, my view of that, by the way, you might not be surprised, is that, if you actually knew all the facts that in the case and paid attention to the 5 cases in 13 years where the SEC has proceeded against a chief compliance officer for their role as chief compliance officer, not if they were involved in the fraud and that kind of thing, that you would read it even if you're, a chief compliance officer, or maybe especially if you are, and say, I get that. I get why you did that here. That's such a gross departure from what we know our job is. But I think that, it's the balance is very important to strike correctly. And it also taught us a lesson about, when you get into these settlements, you try on behalf of the firm or the individual to negotiate what that document looks like. And sometimes that is involved not having some of the worst facts in it. And so then you're sort of looking at a truncated version of the story. And that's it. Why in the world did you do this? So at the SEC end, at the DOJ end, it may not please you when you're on the other end of this stick, but you've got to sort of be transparent about why, this really did justify a charge.
One thing I would just add is that, the 5 is just the tip of the iceberg, and that's one of the issues, is that I think the regulators have more reflexively said, hey, let's take that compliance officer's testimony. And that has an incredible chilling effect that I don't think we should ignore. And you see it particularly in the anti-money laundering area, where I think compliance officers feel real personal exposure. There are lots of times I've heard around the industry where, in trying to fill that job, a candidate has said, effectively, life's too short. I'm not going to put myself in that chair. And that's what I'm afraid of, and we want to stay clear of that. We do want the best people sitting in those chairs, and if again, it's a matter of have we struck the right balance? If we go a little bit too far, and if we're reflexively saying, hey, what did the compliance officer do? Because believe me, it's not comfortable being in a testimony room with the government on the other side. You're going to drive people out of that function, and you're not going to have the kind of robust compliance that you want.
There's another question over here. Yeah.
As a private practitioner in the bank regulatory space, one of the things that I've seen over the last, certainly since the financial crisis, but even preceding that, is that the agencies are more and more operating beyond the regulations by kind of the lore that those of us who practice in the area know where the rules, where the kind of lines are drawn, but they're not written down in any regulations. And you see even a reluctance from the agencies to promulgate regulations, because then if you had bright lines and rules, then they'd have to actually stick to them. But instead, things kind of, once everybody kind of gets to this line, then the line gets pushed a little bit further the next time you talk to them, and so on. And it creates a real problem, from my perspective at least, because those parties that are conscientious, that want to do the right thing, if a government lawyer tells them, no, you can't do that, they immediately back off. But then you have other actors that I've seen that aren't as conscientious and that are more cavalier. The government lawyer will say the same thing, no, you can't do that, and they'll call up their lawyer and say, where is that in the statute or the regulations? And the lawyer will say, it isn't, but that's what the agency is saying. And they'll say, well, we don't care, they can sue us. So then, very few times do you see the agency ever do anything after that. So what you have is a lot of areas where they're occupied by people who are not so conscientious about the law and where the line should be drawn, whereas the good actors, the Boy Scouts, are kind of crowded out of that because they don't want to do anything if a lawyer at one of the agencies has said, no, you shouldn't do that, even if that's not really what the law says. A, do you think that's a fair assessment? And B, what do you think can be done about that?
I mean, I certainly ran into the phenomenon because some of the rulemakings that we did with the banking regulators, and they have supervisory authority. So we would be saying at the SEC, my former how do you enforce this? I mean, you need something that's specific that says, do this, don't do this. Don't worry about that. I mean, they didn't need to worry about that because they have the broader, kind of umbrella. I think that's a dangerous thing. I mean, not only does it lead to some inequities, but it's kind of anything they say it is. And so one of the other complaints, and I'm not trying to, absolve the SEC from, the criticism, but it's different, I think. And one of the things that we would hear from our sort of, our overlapping regulatees with the federal banking regulators was, they're kind of in the boardrooms telling the companies how to run their business as part of the supervisory authority. So not only can it lead to sort of that inconsistent kind of behavior and the good guys and the bad guys, but also I think the government, the regulators having a broader function than certainly they were intended to have. But Steve, you've probably been at the short end of this stick, perhaps. So I will.
Well, actually, this reminds me of a conversation that was very much in the public arena when I was at the commission. So this is like back in 2004, 2005. All the rage was principles-based regulation, and the model for that was London and the then FSA. And a lot of the financial services industry was clamoring for that. We want that. That's regulation light. And I remember thinking at the time, be careful what you ask for, because one, you better trust the regulator in that regime, and two, the regulator better trust the regulated. Otherwise, principles-based regulation doesn't work. I'll tell you where else I don't think principles-based regulation really works is if you're an if you have an enforcement-first framework, which is sort of a little bit how I think about the SEC. Until 10 years ago, the number of enforcement actions you'd see the Fed or the OCC bring was very, very small. As they've become more enforcement-minded, I think, people are sort of thinking twice about, hey, is that a regime that we really like? Do we want to be held, do we want to be brought to an account in an enforcement way rather than a supervisory way on the basis of we don't think that's the way you should be doing business, and it's not written anywhere.
One more
I probably
question.
didn't answer
No.
the question. But.
Take one more question. Yes, right here.
I wanted to get your opinion on whether or not you think the passage of the DOL fiduciary rule is going to have an impact on mandatory arbitration of customer disputes. I mean, as people's retirement savings are bound up entirely in IRAs at this point as opposed to pensions, and they're entirely dependent upon FINRA dispute resolution, where you have more and more restrictions as who can serve as an arbitrator. Is that really, from a policy perspective, a good idea for how retail investors can manage disputes they have over how their money was invested?
You mean not allowing mandatory arbitration in effect?
No.
Or the opposite?
The opposite,
Yeah.
saying that everything has to be arbitrated, and your arbitrators may not even be lawyers, and they may not be people who know anything about securities.
Look, this is one, I'll speak from the SEC perspective rather than the DOL perspective, but the principles, I think, are the same. That was another of the Dodd-Frank provisions that gave the SEC the right but not the mandate to impose, basically to ban mandatory arbitration. And I paid a lot of attention to that because, for all the reasons you're stating, frankly. But each time I came up to the line of thinking, okay, I'm going to exercise this, or try to exercise this authority with my fellow commissioners, I was persuaded that the investor would be worse off without that forum. Now, class action situations, as you know, are treated somewhat differently and informally. So I think it's a hard issue. I think it's a very hard issue. I don't think it's the investor's better off one way or the other, though.
No?
That's also one of the Choice Act.
I happen to be on the board of FINRA.
Fair enough. Okay.
Yeah.
We'll leave it there.
I actually think there's a lot of value in the arbitration
Yeah.
process and system, but I should leave it there.
Let me just ask you lastly here quickly, as we're short of time. When you look at D.C. and the uncertainty therein, is the uncertainty about policy or about how we find out what policy is going to be, if that makes any sense? Have processes in Washington changed as a result of this new administration coming in, or are we just not clear about what the administration intends to do?
I think it's more the latter at the moment. But I mean, I think it's I think whatever change happens is going to come several years down the road by virtue of how the regulators carry out their jobs with the different kind of philosophy we've been talking about. But I think it's both uncertain, I think, where the administration is actually going to land on policy, and then there's uncertainty as to whether they could bring that about even if once they landed. But
Steve?
Oh.
I'll go back to Hamilton.
Yeah?
I think it was George Washington.
am I the only person who hasn't seen Hamilton?
Yes.
Because I've been
Clearly
the prisoner of
you've
Second
been
Avenue in
busy.
Washington. I mean, it's like, I'm going, though, in August.
Good.
Okay.
I think one of the lines from George Washington in that play is, "Winning is easy, young man. Governing is hard."
Yeah.
Governing is really hard. Regulating is really hard. And I think, this administration found out during the first several months legislation is particularly hard. I think, I do think even regulation is hard. And, there's a reason why the Secretary of Labor said, we're just going to keep going with June 9th. I think he thought it would have been a very tall order to do anything but that. We'll see. This isn't going to be let's just get rid of the old and here's the new. First of all, a lot of the old made sense, and I think people recognize that. And what I think regulators are conscious of, and I hope the industry is conscious of, is you can go two steps too far in deregulating. And I have told colleagues, be careful. Make sure that you're not advocating for a form of deregulation that's simply going to sow the seeds of more regulation in the future.
Yeah, and I will say one vignette I had after the election. I happened to be meeting with a lot of CEOs on I guess it was the Financial Services Roundtable that I mentioned, and I basically said exactly the same thing. I mean, clearly a weight had been lifted because all of a sudden it wasn't quite the class warfare against Wall Street anymore, at least in terms of what was expected by the new administration. But I said, we need adults in the room here. I mean, you need to be adults in the room and not be, greedy. I think we use the same word, because a lot of this makes sense, and if you get really radical change that, has very negative consequences or may for investors, the markets, et cetera, the pendulum is really going to swing back the other way. I mean, I must say, I've, from watching it, both while I was still at the SEC after the election and now, I think, the industry's being pretty responsible. And you don't hear people saying, let's get rid of all of Dodd-Frank, let's, including all the capital requirements, the Basel requirements, et cetera. So, we'll see what happens. But, predicting where it's going to land, I don't expect there to be certainly dramatic regulatory and legislative change.
All right, regulating is hard. Moderating this has been very easy for me. Thank you both very much for the time. Appreciate it.